Lord, with one or two judgments. Lordships may just hear me on the requirement of an interim protection.
My Lord, my respectful submission is.
No, I'm not going to grant any order without hearing you. Don't worry about it.
Yes. Yes. My Lord, matter arising under, my Lord, the provisions of BNS and POXO. But I must satisfy this honorable court that while, my Lord, the victim would have to be heard when, my Lord, whenever they are going to assist your lordships, I am entitled for an interim protection. But I am in an anticipatory bail. I am not asking for quashing of this particular matter. My Lord, my case is very simple. But if your lordships were to look at that particular complaint in relation to which, my Lord, I am seeking interim protection, but my first submission for your lordships would be that the complaint on its own terms would make out, my Lord, mitigating circumstances, my Lord, as several courts have held, for the purpose of granting me interim protection. But eventually, Lord, because today your lordships are not hearing the anticipatory bail grant or rejection, my effort will be to show to your lordships a very limited point, which is this matter would have to be heard at the request made by the victim, or the PP also may want to assist Lord at a particular date. Do I make out a case for grant of an interim protection in the particular meantime? Lord, lordships will hear two objections, Lord, so let me meet with them straight away. Lord, one objection that I foresee possibly coming from them is this honorable court is being approached directly without approaching the sessions court. Lord, I'll place two Supreme Court judgments, Lord, which are categorically stated. It's a concurrent jurisdiction. We can approach this honorable court directly. Lord, once it is a concurrent jurisdiction, that objection, my Lord, in my respectful submission may not have much teeth. But what I will do is I'll preserve my breath. I will deal with this if they make this particular argument. But I'm supported at least by two Supreme Court judgments. Lord, the second objection, my Lord, that they would say is about notice to victim. My Lord, victim has been intimated. Lord, there's a counsel appearing. As I said, my Lord, while lordships would hear the anticipatory bail after hearing the victim, I'm entitled to make some submissions. Lord, very quickly, I'll move, my Lord, to the points I want to make for your lordship's consideration. Lord, an offence under POXO, no doubt, my Lord, is treated as a grave offence. But, my Lord, legislatively, my Lord, they have ensured that there is no bar against grant of an anticipatory bail. But I'm making an argument only for interim protection till my anticipatory bail is to be considered. If I'm able to satisfy...
So what is the interim protection that you're asking?
But I'm asking that I should not be arrested by the police because I want to assist the police. My Lord, till your lordships hears the anticipatory bail, whichever date, including tomorrow. Since your lordships have indicated your lordships are sitting tomorrow, I'm here to assist your lordships even tomorrow. Let them not affect arrest, my Lord, because this person wants to go join investigation and show some material. It will take me 15 to 20 minutes to show to your lordships that I have a case, my Lord, that I will be able to make out before the police for the purpose of satisfying the police and the investigation team that this complaint made against me is completely false and is frivolous. It would not come within the meaning of, my Lord, the offences under POXO. I will show your lordships a few judgments, but within this 15 to 20 minutes only for the purpose of satisfying this honorable court, that my anticipatory bail deserves, my Lord, a proper hearing by this honorable court. If it deserves a proper hearing, in the meantime, if I don't have an interim protection, the police, my Lord, they have indicated they are already trying to take me into custody. If they take me into custody, my Lord, my anticipatory bail will become infructuous. If they are ready to argue today, I'm ready to argue my anticipatory bail. But I concede that they cannot be subjected to this discomfort.
Why POXO will not apply to you?
Lord, two submissions. Lord, first, Lord, I'll make the case at a higher level. Even if POXO were to apply to me, my Lord, the interim protection can be granted, my Lord, I have settled judgments of this honorable court. In certain mitigating circumstances, I will be showing to your lordships, my Lord, that I clearly come within those exceptions and those mitigating circumstances where an interim protection must be granted to me, and maybe I'm entitled to the grant of an anticipatory bail. Lordships, just gives me 5 or 10 minutes, my Lord, I'll just set out my case very quickly. First submission, my Lord, for your lordships' kind consideration. This will I'll argue more elaborately when your lordships hear the anticipatory bail, is there is no bar against grant of an anticipatory bail under POXO. Unlike, my Lord, SC/ST Act. My Lord, when the legislation wanted to forbid, my Lord, the even consideration of an anticipatory bail, it legislatively provided so. Which means, my Lord, the legislature did not want to bar the applicability of 482 BNSS, old 438, in relation to a crime registered in relation to POXO. Which means, my Lord, that even while the legislature, and my Lord, now several courts have been behoving, my Lord, the legislature for the purpose of making some amendments, but even when the law was made in the most stringent form, the parliament did not think it has to be so stringent that an anticipatory bail should not be maintainable or should be barred, unlike SC/ST Act. So, my Lord, in law, anticipatory bail I'm entitled to file, and the court, my lord, would consider on its own merits. My lord, second, my lord, the courts have clarified that the presumption under section 29, my lord, which is presumption when an allegation is made that this offence under POCSO has been committed. But now several judgments, and I show only one judgment which covers all these judgments, specifically say presumption applies only after charges are framed. It does not apply at the stage, my lord, your lordships are considering bail or the grant of anticipatory bail. So there is no presumption and there is no bar against consideration of anticipatory bail. My lord, then what would be the parameters that would apply in relation to the grant of an anticipatory bail? My lord, which are arguments, as I say, which, my lord, I may have to make tomorrow or whenever your lordships are inclined to hear the matter. The parameters would be the regular parameters, my lord, of an anticipatory bail in relation to any IPC offence, my lord, which is now BNS offence, which would be, my lord, the relevant standards in relation to an anticipatory bail, my lord, Gurubaksh Singh, Siddharam Sethalinga Maitre, my lord, and also, my lord, the latest judgment of Sushila Agarwal, 5 judges. Whatever your lordships consider for grant of anticipatory bail in respect of a regular criminal offence, same parameters would apply in relation to the grant of an anticipatory bail also. But one special feature in POCSO, which, my lord, judicially has been carved out, is it would matter a great deal to see the conduct of either party. The conduct of the victim, the conduct of the accused, and, my lord, another feature that your lordships have now read into in POCSO, my lord, your lordships have recognized that POCSO was originally brought in for the purpose of preventing exploitation of children, but people in a position of authority, including relatives or my lord, any person having any kind of authority. It could be a teacher, it could be anybody having control of the children. They were, my lord, unfairly exploiting the children, my lord, for several, my lord, immoral purposes. The law was intended to curb that particular mischief. But there was always a separate offence in relation to, my lord, a sexual harassment. There was always a separate offence in relation to, my lord, an allegation that may constitute rape in a particular matter. It needed that extra feature that this has to be a child, my lord, who is of such defenseless capability, because, my lord, the child is very young. It needs, my lord, someone exerting influence to do it. The point, my lord, that your lordships have set down, but I know, my lord, your lordships are under tremendous pressure. I'll try to be as quick. But, my lord, the point that your lordships have finally settled upon is, in relation to POCSO, if a child is above 16, some high courts say, some high courts, my lord, say it can even be 15. If 15 to 16 to 18 is the age in which the victim is, it would still be a case of POCSO if a case of POCSO is made out. But there, my lord, the conduct of the victim becomes extremely relevant. Your lordships have said that would be a mitigating factor at the bail stage itself, not at a trial and conviction stage. So, my lord, in these parameters, Lord, I want to place the complaint for your lordships for the purpose of making an argument that till whenever your lordships are going to hear this anticipatory bail, I am entitled to the grant of protection. Now, would my lords kindly have the complaint filed, my lord, which is FIR starts at page 13. The complaint itself starts, my lord, at page 16. 16, 16. My lord, I just wanted to make one request. I understand, my lord, your lordships already got delayed in the division bench. I'm here the whole day. If your lordships would want to, my lord, only thing is because I'm asking for interim protection. I can take, my lord, the next 15-20 minutes. If your lordships want to take it up before your lordships rise, I'll wait so that, my lord, the other advocates also need not wait.
Because take up tomorrow.
No, my lord, tomorrow, my lord,
I need some time because
then let me make out my case. Let me make out my
I can
case.
see is there are no 161 statements. 164 statements seems to have been recorded today. That will also come out. And in the original complaint, there are several details which the girl has not mentioned. And she has gone to the extent of saying that section 511 attracts, which is punishable at 20 years or life.
Then let me. If my friend has instructions to argue, he can argue. I'm sorry, my learned friend cannot.
Be appropriate. My respectful submission is kindly grant me some time, a week's time. I'll file detailed counter. Your lordship will hear the matter at length. The interim protection is as equal to an anticipated bail application.
Then let me make out a case.
So what is there? See, you have to make out that it's either not a POCSO case. Okay, you have made advanced argument saying that about the maintainability of the bail petition here without going to the trial lower court.
Yes.
And also that this court can grant bail even in POCSO cases. These are the two arguments made by you.
Correct.
But my question is, if it is, whether, you seem to have said that she is not a child or below the age of 18.
In my bail
So,
petition, I've said.
in the bail
Yes, ma'am.
petition, you have said. So are you trying to make out that this is not a POCSO case at all? If that is so, come directly to the point where you have any evidence that she is not, she is more than 18 years
Yes,
of
ma'am.
age.
My lord, if I may just show that this is something that will require, my lord, this honorable court to consider. My lord, there
You
was
also
an
will have to
FIR
satis-
registered.
No, and you will also have to satisfy that how we are different and why should any interim protection be granted to you?
Yes.
How we are different from any other accused?
But I am,
Because the same courtesies are not being extended to everybody.
my lord,
You should show what is that urgency in your case,
Yes.
that you should be granted this.
my lord, may I deal with in the reverse order. My lord. That is
Yes,
most
come.
important. What your lordships asked. I am no different from anyone.
Then,
But I am entitled to, my lord, seek your lordship's indulgence as, my lord, any other person who, my lord, can come before this honorable court and make a request. But today, whenever my lord, I'm making a request today, and your lordships would see every of my argument, my lord, will be steeped upon any common man approaching this honorable court and making a request. And I'll be referring to, my lord, judgments of this of various courts, my lord, which only refer to cases made out by, my lord, ordinary citizens of India in respect of whom protection has been granted. So, my lord, first I want to dispel, my lord, any impression that there is anything important about this person. No, I'm sorry. But there's absolutely nothing important. There is nothing special. My lord, this person is as common as any other person. So, my lord, I have not made any submission.
so what are the circumstances? Why do you need that interim protection
Yes,
now?
ma'am. Now, two submissions. But if I may just indicate what my arguments are going to be. My lord, the courts have said that in a POCSO case, my lord, the entire POCSO case itself is predicated on the age of a victim. My lord, I will make my arguments at two levels. First argument for your lordship's kind consideration is, in a charge sheet filed by the police in relation to the victim in an earlier instance, my lord, the police had identified the age of this victim about 5 years back as 15 years. If the police charge sheet is correct, and if the police were to be correct, my lord, in the charge sheet for an underage driving, some case was registered and a charge sheet has come to be filed against the father of the victim, showing the victim's age, my lord, at that particular point of time of as 15 years driving a car. So the father, my lord, obviously child can't be prosecuted. The father was, my lord, charged. If the charge sheet, and your lordship, my lord, will proceed on the basis is not an FIR, a charge sheet that was filed, then there is a reason for the court to have some suspicion at this particular point of time. Is the child really, my lord, a minor at the time that this alleged incidents are referred? This is one submission. Subset of the same submission, first submission itself is that, my lord, the birth certificates that are placed show different birth certificates of this particular victim taken from different entities. So, my lord, there is a great amount of confusion about the age of this particular child with regard to whether she can be classified as a victim. My lord, under the POCSO Act, if she is below 18. So, my lord, this is going to be my first submission. In any event, my lord, that may be a matter for investigation. They may come to some final conclusion about it. But, my lord, the material that is there before your lordships would not be able to rule out that if, my lord, some of this material were to be eventually found true, that this person is not below the age of 18 years age, my lord, then the application of POCSO provisions in relation to me, and, my lord, subjecting me to any arrest or not being entitled to the grant of any relief may result in miscarriage of justice. And as I said, my lord, the police will come and try to assist your lordships with regard to these various dates that are floating, which to my extent, whatever I could gather, I have placed before your lordships. Now, second submission I am making on demurrer. Not for any reason, if the court feels that at this stage it cannot be decided that the age is above that age of majority, and the court may have to go on the basis that it is a case that may come under the aspect of POSCO, that I am making a slightly different argument. Even if it is a case of POSCO, even according to the victim's mother who is the complainant, and even according to the police, the child, my lord, is aged about 17 years. If the child is aged about 17 years, and, my lord, if I am able to show to your lordships, my lord, from the conduct of the victim and, my lord, the circumstances that are existing, that this is not a case, my lord, which would come within the mischief contemplated by POSCO originally. Your lordships will also hear an argument that consent is immaterial if the age is below 18. But I am not even speaking of, my lord, consent being given voluntarily. There is absolutely nothing to show, my lord, that any offence under POCSO was committed by me, especially, my lord, the aggravated assault my lord, that they are now trying to press in relation to me. So if I am able to show to my lords that, my lord, from the complaint file, if those sections are not made out, the aggravated ones, the sections that, my lord, originally were pressed against me were 11 and 12, for which, my lord, the punishment is 5 years and below. My lord, both IPC offences, which is BNS offences, and, my lord, the POXO offences on which FIR was registered are all offences punishable below 7 years of age. My lord, then there would be no need for arresting me. Arnesh Kumar would directly apply. What they do is they file the FIR. They understand that this would not come above the age of, my lord, punishment of above 7 years. They improve upon that case, my lord, in a statement that they are giving thereafter, leading to an alteration of memo. My lord, for bringing in the section 5 and section 6, my lord, which my learned friend was trying to point out. Now, those are cases, my lord, where offence goes above 7 years. And I am going to show to your ladyship, my lord, a judgment of the Supreme Court which says that if there is an improvement made, if there is an embellishment, if there is an ornamentalizing in relation to a complaint filed, especially with a delay, then the court would have a reason to take it with a great deal of suspicion. Two very, very strong circumstances your lordships will find in this particular matter is, the allegation is, the alleged relationship started in June. They use the word relationship. They say 2 incidents happened October, November. Last of the incidents they complain about happened on 31st December of 2025. Not very important. No complaint filed, no FIR filed till 8th May. When they filed the FIR on 8th May, the complaint itself specifically says we were weighing legal options to be pursued in the month of March. And when your lordships see the complaint, your lordships will notice the complaint, my lord, is with full clear understanding of all legal aspects. Complaints refers to the law, refers to judgments, and complaint was given on 8th May. If such a well-informed complaint given after 4.5 months, first, it straight away throws in any element of doubt with regard to the correctness and veracity of the allegations made, and I am supported by a Supreme Court judgment directly on this point. Even if, my lord, your lordships want to take it as true, at this stage when I am asking for interim protection, that complaint and the offences that were registered on the basis of that complaint are all for offences below 7 years, which will not require my arrest. If there is, my lord, a buffering and improvement of the complaint that is happening thereafter, my lord, then your lordships might see that there's a clear pattern for the purpose of trying to fix me where I am taken into custody, my lord, for wrongful purposes. Now, my lord, this would be my effort to show to your lordships. My lord, there are 4 incidents that are referred. Each of the 4 incidents I am going to show to your lordships. Prior to the incident and post the incident, there is a bunch of communication, my lord, between the victim and, my lord, the accused that I am representing, which were all very cordial, extremely cordial. The mother comes and says 4 incidents on 4 dates, my lord, and it will take me exactly 10 minutes when I take your lordships through the sequence of, my lord, messages. There were telephone calls for 8 hours, 10 hours, my lord, in those, each of those relevant periods. And, my lord, the allegation in the complaint is, my lord, I don't want to vilify anyone. My lord, let me, my lord, start with a sense of responsibility that this may be a child below the age of 18 years. I don't want to vilify. I am only trying to meet allegations where I am sought to be vilified. So, my lord, please understand my arguments, where I don't want to make any comments against the victim or any other person, and I am being very careful. I will not, my lord, overstep my boundaries in relation to any of, my lord, the state. I am only placing a few facts for your lordship's consideration, which is with evidence. Each of this evidence I will be able to take before the police and satisfy the police. But the allegation is that I have taken this person from place to place against her wish. And I will show to your lordships, around these 4 incidents that the mother complains, it was the person who was picking and identifying the places that they wanted to visit. Not for the purpose of, my lord, having any, my lord, penetrative, my lord, the offences that are going to be classified. They were just a group of friends. They were meeting, and, my lord, the complaint itself refers there were 4 or 5 people at each place when they were meeting, and they were meeting together. There is a more serious allegation in relation to 2 instances, and I will show to your lordships, pre and post that instance, there is a bunch of material which specifically says exactly prior, exactly after. My lord, they have been in complete, my lord, as I said, conversations which were very, 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 very cordial. So, my lord, For the purpose of consideration of, my lord, now when if I'm able to place this material for my lord's kind consideration, the issue would be, am I entitled to the grant of an interim protection? Normally, your lordships always hear, this is a grave offence, anticipatory bail should not be granted in a case relating to POCSO. I will show your ladyship, my lord, 3 judgments of the Supreme Court, where interim protection granted by the High Court, interim bail granted by the High Court has been confirmed by the Supreme Court. So as I said, my lord, anticipatory bail is not foreign to this law. Supreme Court judgments say once there is anticipatory bail power, your lordships always have the intrinsic and inherent power to grant interim protection. Interim protection, when granted, never interfered, my lord, by the Supreme Court saying that they could not have granted interim protection. Everything turns on the facts of each case. Now, my lord, I come back to the last question lordships again asked. What is special about this particular case? My lord, my answer is, the facts of this case are special because in the facts of this case, I am going to satisfy your lordships 100% that this allegation and the complaint is completely frivolous. My lord, serious allegations are made against me, which are going to be, my lord, displaced for your lordship's perusal in 5 minutes each. I will show in 5 minutes each, my lord, each of the allegations and say how, my lord, there's absolutely no truth to this particular one. My lord, the lordships have also held in the judgments that if such a case is made out on facts, so my lord, person is not special, every case will be decided on the facts of its own case. If in the facts of this case, if I'm able to satisfy my lords, my lord, that this is a case where your lordships may have to consider anticipatory bail more seriously. That's all. Then your lordships, my lord, would grant me a limited protection. I am ready to argue tomorrow. I am ready to argue whatever time